Okay, so today we're having a guest for our Taxport Group company clients and our followers. And we have a very painful topic that we receive a lot of questions. So we decided to get direct answers from professional. And today we have a guest. It's Peter Murray from a multi-award winning insolvency firm, Insolvency Law. Hi, Peter.
Good morning, Valentina. How are you?
I'm very good, thank you. How about you?
I'm wonderful, thank you very much.
Perfect. So if you're ready, I'm gonna go with the questions because we had quite a few questions from our clients and followers to ask.
Surely.
So, yeah. Okay, so first of all, could you just introduce us what is actually liquidation of the company? What is it?
Okay, so liquidation in very simple terms, it literally is the end of a company's life, i.e. The directors, the shareholders have come to a conclusion that the company can no longer continue to trade and meet its liabilities, and therefore it is no longer fit for purpose, and therefore it should come to the end of its life. And that is, in other terms, that's the burial of a live limited company, so to speak. Right. And that is performed by a licensed insolvency practitioner, licensed by the government by act of law to liquidate the company for the shareholders and creditors.
Okay, how long does it usually take to liquidate the company?
Oh, a liquidation, a creditor's, a insolvent liquidation can take anything literally from 1 year, literally to a number of years. I was only reading yesterday, I received notice yesterday with regards to one of our clients. It's an ongoing liquidation, and the liquidation is now entering into its 6th year. Sixth year, yeah. So they can go on and on if there are still matters to conclude by the liquidator, investigations and so forth. But usually, a liquidation can be complete within 12 months to 2 years.
Right. Okay. So, like an average is from 12 months to 2 years.
Yes, and that's provided, of course, the books are very well maintained, and there are no investigations by the licensed insolvency practitioner, by the liquidator. There are no outstanding matters to conclude. There are no claims being brought by the insolvency practitioner against any third parties. And so, as long as, those boxes can be ticked or covered up pretty quickly, then a liquidation can be concluded in around about 12 months.
What about the debt amount? Is there a minimum debt amount that is required to enter into liquidation?
Good question. There's no minimum amount as such. The company, to enter into insolvent liquidation, it's really just being able to demonstrate that the company is unable to meet its liabilities as those liabilities fall due, whatever amount those liabilities should come to. There is no figure on it. It's just, the company's unable to meet liabilities as they fall due.
Is there a maximum amount of the debt that is, if, for example, company has millions of pounds of debts, can it still be liquidated?
Absolutely. There is no quantum, so there is no minimum, no maximum amount. The test really is the company's unable to meet its liabilities as they fall due. For argument's sake, a company could have, let's just say, £500,000 in assets, and let's just say those assets are fixed assets, like property, bricks and mortar property, and the company has a debt of, say, has got liabilities of, say, £100,000. And so on one hand, we have £500 assets. The other hand, we have £100,000 liabilities. But these liabilities are due to be paid now. Right. And the company has no cash at bank to pay this £100,000 worth of liabilities. According to our law, the 1986 Insolvency Act, Section 123 of the Insolvency Act, it does declare that the company is insolvent because it is unable to meet its liabilities as and when they fall due. So although the company has £500,000 worth of assets and only £100,000 in debt, in liabilities, that company is deemed insolvent and can be wound up voluntarily by shareholders and the creditors, or by the courts compulsory.
Right. Okay. Are there? Could you just go briefly with main advantages of liquidating the company?
The main advantage of liquidating a company is you recognize as the directors, they would be the first to sort of spot the company as insolvent, and then will need to report it to the shareholders. Oftentimes the directors are the shareholders, and once they've come to that conclusion that the company is insolvent and it can no longer meet its daily obligations, especially its obligations to its creditors, its liabilities to its creditors, and then the directors ought to take steps to wind the company up, and that is to put the company into insolvent liquidation, and it's really it's ratified by the creditors of the company. Mm-hmm. And the insolvency practitioner is appointed by the creditors as the licensed liquidator, and that liquidator will then set about liquidating the company. And to liquidate the company, what the liquidator does is obviously the liquidator gathers in all the books and records belonging to the company. The liquidator gathers in all the company's assets and liabilities. It notifies creditors with regards to the extent of the company's liabilities, and it gives creditors an indication based on the assets available in the company for realization for the benefit of creditors. It will give creditors an indication if creditors stand to recover anything from their debts as a result of the assets being liquidated by the liquidator. Oftentimes the cost of the liquidation is quite expensive, and the liquidator's fees and expenses must be met first, and those fees and expenses are met from the proceeds of the assets that were realized by the liquidator. If there is a surplus after that, the surplus proceeds would then be distributed to the creditors of the company in order of priority and in rank to what each creditor is owed.
What would you say would be disadvantages of liquidation, or more not really disadvantages, but maybe implications of liquidation? What can go wrong?
Well, oftentimes a liquidation cannot be avoided. If a company is insolvent, if a company is unable to meet its liabilities as they fall due, eventually that company will actually run out of steam, regardless, how savvy the directors are, because debt liabilities always tend to catch up with you if you don't pay them, of course. And so at some point, if you don't voluntarily submit that the company is insolvent and take steps to put it into liquidation, dare I say, a creditor, probably HMRC or a trade creditor, will do it for you, and that will be compulsory. They will make an application to court for the compulsory winding up of the company. And so sometimes there's no avoiding liquidation, it is an inevitability. And there are disadvantages of liquidation, of course. If the directors of the company have committed some type of misfeasance, if they have misappropriated company property, if they have unpaid directors' loans, if they had distributed company assets, especially funds, to third parties, or parties or companies or individuals that are connected to the directors, if they have done so during the course of the company's insolvency, or if those actions, when committed, had technically rendered the company insolvent, a liquidator can make a very successful claim against the directors of the company for the return of such funds. So those funds would then be returned to the company. And so that's what directors really ought to take note of. They cannot treat, as many do, the company's bank account as if it is their personal bank account.
Okay. That's a very good point to say, though. Are there any implications for the director of the company for, if they are liquidating the company and their debts? Let's say the books and records are correct and, clean and there's nothing to investigate. And are there any implications to the director at all?
Well, if the books and records are up to date and if they're fairly transparent, and from the books and records, it can be evidence that when the company became insolvent, early action was taken to enter the company into liquidation. And if that can be demonstrated from the books and records, and the directors of the company had behaved properly, then there should be no issues with regards to would there be any repercussions for the directors. So they really should be no issues. It's only when the directors, they continue to trade, when they ought to have known the company is insolvent, and they continue to take credit from suppliers whilst knowing the company is insolvent, or ought to have known the company is insolvent. Because taking credit from companies, suppliers in that situation puts those suppliers to risk unnecessarily. And so, the directors ought to have known that. So when you trade recklessly, that usually is an issue and could lead to directors' disqualification proceedings being brought against those directors by the government's insolvency service.
What does it mean, directors' disqualification?
Directors' disqualification are proceedings, they're civil proceedings, they're brought by the insolvency service, which is a statutory agency of the business enterprise energy, I think, business energy and industrial strategy. It's a government department. They keep changing their name every time a new administration takes power. Yes, they are the prosecuting authorities and will bring proceedings for the disqualification of a director. And if successful, directors' disqualification proceedings, the disqualification period is from a period anywhere between 2 to 15 years, and 2 years being for less grave offences, and obviously 11 to 15 years is when the offence is fairly grave, and between 6 to 8 years it's medium range offences, where the directors of the company have misplaced or cannot find or have not delivered up to the liquidator the books and records of the company. Some directors feel they deliver up the books and records to the liquidator will forensically examine those books and records and uncover misdeeds committed by the director. And so the director thinks, well, if I don't deliver up the books and records, then the liquidator won't know these things. But it is actually an offence and not to deliver up the books and records in a liquidation to the liquidator. And by not doing so, the directors of that company are almost certain to be prosecuted by the Insolvency Service under the Directors Disqualification Act. But yeah, it is quite serious. And if directors, do not act in accordance with, UK insolvency law and or company law, directors can find themselves on the end of disqualification proceedings.
Does it mean that they are not allowed to be company directors? Disqualification, is that right?
Yes. So if a director is disqualified from being a director, that period would be anywhere from 2 to 15 years. And if they are disqualified, then that director will be prohibited, i.e. banned from being a director of any limited company for that period. And should that director continue to act as a director, indirectly or directly via itself or via a third party, i.e. if the director continues to be concerned in the promotion, management or running of a limited company, either directly or indirectly through a third party, that director is guilty in breach of the disqualification ban. And the punishment for that is a term of imprisonment for up to 2 years. Wow. And the director will be personally liable for the liabilities for the debts in the new company where the director are traded from.
But if they can't be company directors, can they still be owners of the companies?
Directors can be owners of a company, yes, but it's very they must be very careful that they do not have any influence, control, management, or promotion over the company's affairs. Because to do so would be in contravention of the disqualification ban.
Okay. Thank you for clarifying that. You personally, how do you come here to help clients? What exactly do you do when you're involved with clients that want to liquidate?
It's good when we meet directors at the very early stage of insolvency, because we're able to give them very sound advice so as not to make matters worse for them. And that advice, usually is in the very first instance, if they are insolvent, if the company is trading while insolvent, then they need to stop trading, while insolvent as quickly as possible. But they also need to ensure that the books and records of the company are up to date. They need to ensure that any directors' loans they may have drawn from the company, then those directors' loans are actually repaid to the company, or there is some credit given to the company in respect of those directors' loans. And just making sure really that, that matters that could cause the directors problems post-liquidation, those matters are addressed prior liquidation, before the director enters into liquidation. So before the company enters into liquidation, And once the company is now ready to enter into liquidation, we will then guide that director. We'll recommend a licensed insolvency practitioner who will handle the liquidation on behalf of the creditors for that company.
So you basically can consult the client and go through his situation personally, what happened, and with the client's honesty, basically you're able to help them to manage the process efficiently. Is that right?
Absolutely. We will literally be side by side, or I'd be side by side with the client from beginning to end. All I ask from the client is that the more the client shares with me and is open to me, then the more I can assist the client and mitigate and make sure the situation is as best for the client as is possible, given that client's individual circumstances.
Okay. So basically it's like being a lawyer, it's the same thing, isn't it? It's important that client is open and honest and brings all the issues forward before company goes into liquidation.
Surely, because we literally will save clients from personal ruin, from personal liability, from criminal liability, and criminal liability leads to jail, and civil liability leads to personal loss financially, and the denial, if you like, of one's livelihood, especially if you are a director or you've got several companies and you want to continue to be a director in your existing companies, then before going into liquidation, you ought to consult someone like myself or companies such as Insolvency and Law, because we are there to literally help you and to prevent you entering into a situation that could usually come out very, very badly for yourself. Last thing you want is to know that you've got to repay funds, significant funds, into the company for the benefit of creditors, or you'll be investigated by the insolvency practitioner or by the insolvency service, or civil proceedings under the Directors Disqualification Act are being brought for your personal disqualification to ban you as a director. So there's some serious consequences that, of course, every director wants to avoid. And that's why they should not enter into the liquidation process without first taking the correct, appropriate advice.
So talking about the advice, we had a lot of followers asking questions around bounce back loan applications and how to handle the situations. If, for example, director gone through with bounce back loan and got like £50,000 of, let's say, the maximum amount, but what they did, they just drawn the money to their personal account because they never took an advice how to handle the money and basically how to deal with this situation. What is the outcome of, of liquidation process? What is it possible? If you can talk through, what there are implications and how should it be handled if they already did this, if they already drawn the money?
Yes. That director absolutely needs expert advice prior to going into liquidation. If it is the case that they have received a bounce back loan from the government and that bounce back loan has been drawn from the company's account and paid directly into the director's personal bank account, that director is personally liable to repay that sum of money to the company for the benefit of the company's creditors, should that company enter into liquidation. Because that transaction is treated as a director's loan, as a loan from the company to the director. And so the director stands as a debtor to the company. When the company goes into liquidation, the liquidator of the company will want to realize all assets, all debtors of the company. And if you, as a director, have taken money from the company, that's treated as a director's loan. You are a debtor to the company. So the liquidator will be asking you, the director, to repay your debt to the company. And you are personally liable to repay that debt to the company. So that really is a situation that does require urgent attention before as a director, you enter the company into liquidation. And if the company has already entered into liquidation and that situation has occurred, rest assured, the liquidator of the company will come to you on the realization of that occurrence, and will seek repayment in full of the loan you took from the company, effectively the bounce back loan.
Is there any penalties for mistreatment of the bounce back loan, for example?
Yes, so there are. I mean, again, it's what we call a misfeasance. When the director knows the position that the company is in, i.e., especially if you have taken the bounce back loan at a time when the company is insolvent, that will be a misdeclaration, because in obtaining the bounce back loan, you declare that the company is not insolvent or threatened with insolvency. So if you made an application during that time, then that was a false application. So that would be fraud, because that would be a fraudulent application, because you falsified the facts to obtain the bounce back loan, and that in itself is a criminal offence, and obviously that leads to jail. But if you obtain the bounce back loan whilst the company, during a time when the company was not insolvent, and you were absolutely truthful in your declaration in obtaining that loan, then that is not a criminal offence. But if you then go on to pay that loan into your personal bank account, or into the personal bank account of another party, or even into the bank, whether that party being an individual or another limited company, without proper reason, that transaction itself can be deemed unlawful, and can be made set aside by the liquidator by order of the court. And so, the treatment of bounce back loans is an issue. Over 1.5 million bounce back loans have been made available to companies in the last 12 months since this pandemic. I think since April. And the government predict that there will be a tremendously high failure rate of with regards to the default rate with regards to the bounce back loans, i.e., applications have been made, but for bounce back loans, and it's been abused. And the government have set up special task force and special agencies in various government departments to investigate, locate, and prosecute those who have abused their application of a bounce back loan.
Well, thank you for your answers. That clarifies a lot. And to finish our conversation today, I have one more question. If you could give one advice, just one advice, what would it be to the company directors who are looking to liquidate the company?
Before they speak to a licensed insolvency practitioner to take that step, they really seriously must take proper professional advice on the current situation. When should they go directly to an insolvency practitioner? That insolvency practitioner is an officer of the court, is a licensed insolvency practitioner, and must act in the interest of the company's creditors, must uphold the law and act in the interest of the company's creditors, not in the interest of the directors. Although they may give you the impression that they will act in your interest to secure your business, once you've given them your business and committed your company, that licensed insolvency practitioner must act in the interest of the company's creditors. And usually, normally, the interest of the company's creditors run contrary to the interest of the directors. And so therefore, the directors should always take professional advice, expert advice, before committing the company into insolvency. Because 9 times out of 10, there are matters to be addressed and remedied about the company's affairs before the company enters liquidation. And that's what the experts will do for you or with you, and then recommend a really good insolvency practitioner who will understand what has happened and will take care of the liquidation going forward.
Thank you, Peter. I think we're gonna just post your details after this video. So anybody who wants to seek professional advice, they can go directly and contact you and discuss their matters regarding the liquidation. Thank you very much for being here today, and really appreciate it. Was very useful, and maybe we're gonna have another video recorded soon as well.
Good. You're more than welcome, Valentina. Thank you very much for having me.
Thank you, Peter.
Okay. Good day.